Well, welcome everyone to Law Talk. Folks, what about your wills and estate planning, okay? Do you really need to be concerned about it? Well, you're going to find out that you do need to be concerned about it. On today's Law Talk, Attorney Conrad Falvello talks about wills and estate planning. Folks, this is a show that you definitely want to watch. Call your friends. This is an important show, and we'll tell you why during the show. Well, Mr. Falvello, how are you?
Good, Sam. How are you?
I'm doing great. Family's okay?
Family's good.
How's the good doctor?
The good doctor, my son, he's very, very busy. Yeah. Very busy right now. As you know, 2 orthopedic surgeons left the area, so as far as the wellness center is concerned anyway, he's the only one there, so he's awake almost all day, every day. But he's very busy. There's a need for that here in the community, and he's doing his best to meet it, him and the good folks at the Alliance. But he's working very hard.
Yeah. For those who want to know what we're talking about his son, Dr. Attorney Falvello, is an orthopedic surgeon in the Greater Hazleton Health Alliance. Dad's doing okay?
Dad's doing good.
Mom and everybody's fine?
Everybody's fine.
That's good. Now, this show today I find extremely interesting. We're talking about wills and estate planning, okay? Mm-hmm. Okay, we hear a lot about probate. What is probate?
Probate, Sam, is actually the filing of the will after a person passes away. And we talk about lawsuits before, you know, we do the injury work as well, but if you file a complaint on a claim, this is the same thing. When you probate a will, you're actually filing it with the Register of Wills here in Luzerne County, and that initiates what we call the probate process. And the probate process is, if you have assets at the time of your death, it is required because basically the state wants their piece of the pie when you pass on to the Great Divide, and you get taxed. I mean, so that's why you have probate.
Now, why is it necessary?
For that reason. The state wants an accounting of your assets at the time of death. And once that, what we call the administration process, the administration of the estate, is more or less complete, you file a Pennsylvania inheritance tax return. And you can pay your tax either at the time you file it, or you can pay it within 90 days of death. They require that the tax return, in most instances, be filed 9 months after you pass away. And that applies to anybody who has assets in their individual name at the time of their death. Would not necessarily apply, for example, if you have a husband and wife, all their assets are in joint names, the first spouse passes away, everything passes to the surviving spouse without tax. However, on the second death, even if you leave your entire estate to your children, it is subject to Pennsylvania inheritance tax.
You know, no one could plan when things are going to happen, and a lot of things happen unexpectedly, okay? And some people I know sit and say, well, really don't have to think about this right now, I'm in good health, or whatever the case may be. But for those people who have a business, okay, how important is that? Because, you know, things happen, unfortunately, and then when they happen, then you're really, you know, you don't know what to do.
Yeah, it is. That's what we call transition planning. If you have a business and you have family members, particularly children, in the business, it's never too early to think about how you're going to transition that business. Not necessarily thinking about at the time that you're going to pass on, but how you're going to maybe, if you have a son or a daughter who wants to continue the business, you want to think about how you're going to transition perhaps some ownership in the business, for example, during your lifetime to that child to have them continue the business. And if you do that, for example, let's say, I'll just use something very easy. Let's say I own my business 100%, and my daughter wants to continue my business even after I retire, not necessarily after I'm dead, but And I say, okay, we sit down and I say, I'm going to have you either buy in or give you 25%, 50% of the business now and over the next several years, transition ownership of that business to you. And then maybe at the end, if I retire, maybe I become an employee or maybe I become a consultant and I can get paid for that. But what that would do, Sam, is then if, let's say, I unexpectedly pass away and my child, my daughter, whoever, owns 75% of the business at the time of my death, then only 25% of that, my remaining share, would be subject to inheritance tax as opposed to 100%. Okay? So that's, again, that gets back to what we talked about a moment ago. That's what we call transition planning. It's a very simple example, but it is something that should be discussed really, I think, maybe not at the beginning of a business, but if you have an ongoing business, let's say a very successful business that sustained itself for some years, and you have a child or children who want to be in the business, certainly it's something to think about.
In putting this together, we talk about sometimes loose ends, okay? Such are, check your retirement accounts,
yes,
insurance, life insurance, business agreements. How does that play into this?
Well, a lot of people, I'll tell you, Sam, I was talking to a couple the other day, and there were a couple who were in their late 50s, two professionals, and they had not made a will before. It was a husband and wife. They had not made a will before, and we sat down and we talked about the will and how they wanted things to go, mostly to children. And then I said to them, I said, what about your retirement accounts? What kind of retirement accounts do you have and how are they set up? And they said, well, gee, I thought this would be all taken care of in the will. And I said, not necessarily, because if you have a retirement account, an IRA, rollover IRA, what they call a SEP IRA, which is like an employment IRA, or even a 401k through your employer, those accounts typically require you to identify a beneficiary. And that means that if you die, then the money in that account can go directly to the beneficiary named on the account. It has nothing to do with your will. Most people, as you might suspect, would name their spouse as the beneficiary, but that asset passes according to law and according to the beneficiary designation and not necessarily through your will. Not that you would want to do it, but for example, life insurance is not subject to tax in Pennsylvania, inheritance tax in Pennsylvania. Most people, again, the beneficiary in life insurance is a spouse, but let's say you had a life insurance policy for each of your children. You can designate them as the beneficiary, and if you die, if you have 3 children and 50,000 policy for each one, they get the money outside the probate process. Doesn't pass through the will, as they say, and is not subject to inheritance tax.
Now, when you're hearing, there's a living document, and then there's an after-death document. Explain that.
Well, I make the distinction when I meet with people and they ask me about a power of attorney. I call it power of attorney because I think it's a simple way to explain it. I call that a living document. That's a document that is legal and enforceable during your lifetime. When you die, the power of attorney is extinguished. It's no longer necessary. And a power of attorney, Sam, is if I could do it, anybody could do it, and there's 2 kinds. One is a general power of attorney, and that says that if I give you my power of attorney to do my business, a general power of attorney would give you the right, legal right, to conduct my business anytime, any place, and generally in any way. It doesn't mean you can do anything you want. It means you have a fiduciary duty to do my business the way I would conduct my business. The other type of power of attorney is a contingent power of attorney, and that says that it is contingent on, for example, my legal capacity or my physical capacity, and would only come into play if I cannot do my business myself, be it most commonly because of some type of illness or incapacity. So those are the two examples, and they would be enforceable during my time. You can present them. Most commonly used, if I have a bank account, my power of attorney can go to my bank and say, I want to put money in, I want to take money out, I want to pay bills. That's the most common use for a power of attorney. But it can be very broad as well.
Who would want to have? Who would want to initiate power of attorney to somebody else? If you're sick, or if you, what would be the?
Most often, as people age, what I call a comfort level, they're more comfortable that what if something happens to me? You know, I want my son to be my power of attorney. Okay. It's also it's very unusual, I think, to happen this way, but let's say you're in the midst of selling assets, property. You can give a person a power of attorney to conduct the sale of those assets. And that's very specific. You can make a power of attorney specific to something like that. But most that we see, typically family members, typically parents and children. But there's another way to do that, because we see quite often where, let's say, dad passed away, mom's getting older and maybe needs some specialized health care, perhaps moving out of the house, going into a facility like a Providence Place, maybe doesn't need intense medical attention, but is in a more social setting and so forth, and wants to give one of the children the ability to conduct that person's business. We see that quite often. That's very typical.
Who handles these things?
Well, a lawyer can put them together. I mean, you can see them on some online services. They call them legal services online. However, you don't get to sit down and discuss individual issues with an attorney.
Yeah, right.
And believe me, I've seen a couple powers of attorney, and more recently a will that was written by the individual, and in the case of the will, really a lot of what was written didn't even apply to this individual. Made it a little bit complex because they came to me after this gentleman passed away, and we had to sort through even whether the will could be filed with the Register of Wills. Even a simple thing, because we were concerned it might have been signed in the wrong place. And that's very important. So although you can do it online, you can do that type of thing, I don't recommend it. I think for a few extra dollars, sit down with an attorney who knows the business, and you can talk about your individual circumstances with
It
them.
always amazes me, Connie, when you have serious concerns, such as your income tax and such as like doing a will. And I know that they spend a ton of money having people go online, and they're telling you all this stuff, and by whether they're true or false, I have no idea. And I'm sure, you know, they have to be factual to a degree, or they couldn't advertise. However, nothing like sitting in front of your attorney or an attorney, getting the information while it's there, or a tax person while you're there, because there's a lot of things that pop up that just you're not aware of.
Well, there could be things that would be, first, that you don't want to miss, or second, you can have an option that might be beneficial to you that online you wouldn't even know about.
Yeah, exactly.
And
folks, I'm sorry, if you just tuned in, I'm talking to Attorney Conrad Falvello. This is Law Talk, and if you want to get in contact with Attorney Falvello, you can go to his website, falvellolaw.com. A lot of information there, or phone him at 570-788-4191. And he'll be more than happy to answer any of your questions. I'm sorry to interrupt you before. But continuing on the same line of wills and estate, which I think are very important, what happens when you die?
Well, when you die, that's when the probate process starts. Let me state again, if you have husband and wife, and predominantly all their assets are in joint names, from house to bank accounts to stock accounts, that type of thing, exclusive of retirement accounts. Generally speaking, you don't need to probate because the asset on the death of the first spouse automatically goes to the surviving spouse, and any asset that goes from one spouse to another at the time of death is not subject to Pennsylvania inheritance tax.
Okay, so a lot of questions come up after that, like who pays the taxes?
Well, let's take it the next step. Let's say the second spouse passes away. So that means that all of those assets are in that individual's name, and let's say that at the time of the second spouse death, all of those assets go to two children, okay? Most likely that person's will, if they have a will, would say, I leave everything to my spouse. If my spouse predeceases me, then in equal shares to my children. And let's say that they have two children, they're both living on the second spousal death. Then most likely one of those children is going to be named the executor. The executor would speak to an attorney, say, what do we have to do? Okay. Well, the first thing you have to do is you get the will, put together some paperwork and file it with the Register of Wills, and then the probate process begins. And here's why. On the second spousal death, let's say there's bank accounts. Well, eventually those bank accounts or stock accounts or both, those institutions are going to report the existence of those accounts to the Pennsylvania Department of Revenue. They have to. And but we just had a situation come in not too long ago where this exact same thing occurred. Second spouse dies. There was only one child living. The child went. We were, I think, 7 months after the death of in this case, the mother. And the child gets a notice from the Department of Revenue that essentially says, you have all these accounts in this bank and you owe this much in tax. And at that point, 7 months after the death of the second spouse, nothing had been done. And this lady came to us and says, well, what do I do with this? And I said, well, you have to probate the will, and we have to file a return and go into that. So eventually, something like that will happen if you don't probate. So it makes sense to probate early, and the reason, Sam, is that in the case I just gave you, where the daughter came to us 7 months after the death of her mother, the time for us to pay a discounted tax rate had expired. The state, because they want to get their money, they have a rule that says if you pass away and your heirs make an estimated tax payment within 90 days of your death, you get 5% off the amount of the tax. Which means that, you know, if you owe...
Amount to some serious
well, it could, sure, because of, you know, you think, Sam, if you have a house,
yeah.
You know, bank accounts, stock accounts, you know, if there's a lot of tax involved,
Sure.
You know, even at $50,000 in tax, that's a $2,500 savings.
Sure.
So if it's paid within 90 days of death. If you don't pay it within 90 days of death, you pay the full amount of the tax.
What if the only heirs are under the age of 18?
Sam, that's a situation that we see. If I have a couple that has young children, and I call it the Corvette question, okay? Because when we're sitting down and talking to them and they say, okay, how old are your kids? And they say, okay, if we, you know, and in that circumstance, we see it quite often that they'll say, well, we're going on a trip, and what if the plane crashes, we
Sure.
both die at the same time, and who takes care of our kids, and what happens? Well, certainly they want to leave everything to the kids, but they say, well, you know, what does that mean? And I say, well, unless you make specific provisions in the will, and both of you die, anything that you've owned, your estate, all those assets will go to your children when they reach majority age, which is 18. And that's when I get the Corvette question, because they say, does that mean when they're 18 they can go out and buy a Corvette? And I say, yes, that's exactly what it means.
Yeah.
So typically what we do there is they'll say, well, no, I want to make sure my kids have enough money for education if they want it. And it's a very simple solution. And that solution is that you can provide in your will that the assets or the share of assets that go to your children can be placed into trust. And the principal, or those assets, can be held in trust for that specific child through any time you want, really. But most people go age 22, 23 to make sure that they're providing financially for the child's education if they need it. And even if they don't go to college, it still provides that they're not getting those funds at age 18. They're waiting till they're a little older, and some take it even beyond that.
So you can stipulate,
especially if there's a lot of assets involved.
yeah, you could stipulate. Okay, let's assume you have a child 16 and 14, or but could you say there, look, my kids, when they hit 18, they're getting nothing unless they get a college education, unless they, can you stipulate that?
Sure.
You
Yep.
can stipulate? And if they don't go to college, they get nothing?
You can't really say that they don't go to college, you get nothing. I guess you can exclude a child if you want, but most people don't. What you would do is say, we're going to hold that money in trust, and it's going to be used for the health and benefit and welfare of that child, or you can even put in a trust it's only to be used for education. You could do that. And then you put an end date on the trust, meaning it'll be held in trust until that child hits age, let's say 25. And then when they hit age 25, you can disperse all of the assets of the trust if you want, and eliminate the trust. Or you could say at age 25, they can get 50% of the principal of the trust, and the remaining 50%, for example, would stay in trust till they reach age 30. So you could take it out as long as you want.
So you can stipulate whatever you want in
Sure.
that. Okay.
Well,
if they get
your
married.
question, I think, is, can you exclude a child from your will? Certainly you can.
Well, let's say this. Let's say, you have that stipulation, and let's say they get married, okay?
Yeah.
Can you say, look, I just want this to stay with my heir and my grandchildren, okay? Or could you make these stipulations?
Yes, absolutely. And most people do.
Yeah.
We call that keeping it in the bloodline.
Yeah.
It's in the usual circumstance there is that question exactly. If I'm doing your will, and you say if I die and my assets go to my children, what if one of my children has predeceased me? And you have two options. You could say, well, then if one child predeceases you, your estate goes in equal shares to your surviving children. And you say, well, geez, all my children have kids, I have grandchildren, I don't want to cut out the grandchildren. Well, then you just simply say, the share of any child that predeceases me goes to that child's children in equal shares. So if you have two children, one child predeceases you, then 50% of your estate goes to your grandchildren, the children of that child that had predeceased.
Executor. What do I do if I'm an executor?
The executor's responsibility is to administer the estate. In my experience, most of that under most simple circumstances is what I call footwork. When we work with an executor, again, depending on the circumstances, but it's not uncommon, we'll sit down and say, okay, what are the assets, could be a house, accounts, what have you. Depending on the circumstances of a will, if a will just says, hey, I'm dividing everything 2 ways, let's say, then typically the assets would be liquidated. That means it would all be turned to cash. House would be sold, stock sold. Cash accounts obviously wouldn't have to do anything. But the other side of the equation is the executor also has to keep track of bills, from the funeral bill to any expenses that would be involved if it's the death of a second parent or second spouse, and now the house is empty. If you have children who don't live in town here, but they're executors, you know, they may say, well, I don't want the house, let's put the house up for sale. So we have to count the value of the house as of the date of death, all of the other assets as of the date of death, and the executor basically does footwork, keeps track of the bills that need to be paid. And then within the 9 months, if we could do it, we put together the inheritance tax return, and that's not unlike an income tax return. You have your assets that are subject to tax. You deduct from those assets allowable deductions, from administrative expenses to funeral expenses to filing fees and so forth, and you come up with a net amount subject to tax, pay the tax, and then once all the expenses and all the taxes are paid, then at that point you can divide the assets.
You know, we got about 2 minutes left, but you know the important thing about this is that, you know, when you're listening to what you're saying, okay, I'm sure many people are thinking of a lot of things, and it could sound very complicated. You know, first of all, you have a tragedy in your life when you lose somebody, and you're a wreck to begin with. Now you have to have your faculties together to put together the house in order, so to speak. So that's why I think it's so critical for people to get all this stuff done before things happen, because you're in a trauma the way it is. Wouldn't you think so?
Well, whether you have a will or not, Sam, that process usually has to take place. Yeah. What the will does is the will is a document that tells everybody, from family members to business partners to whoever, this is the way I want things to be after I pass. Yeah. Okay? If there's no will, you still have to probate the estate. It's probated according to what the state mandates, meaning your estate would be divided according to statutory provisions, okay, which you may not want. So that's, I mean, so meaning, oh, you might say, well, geez, you know, my nephew so-and-so is going to get a piece of this.
And he never did anything for me.
Right.
You know, but, that's the sad part.
So that's why it's good to have a will.
That's why I said at the beginning of the show, folks, this is a very important show. Folks, I'm talking to Attorney Conrad Falvello, 570-788-4191, or go to his website, falvellolaw.com. Wills and estate planning. I know it's something that you don't even want to think about, but folks, you got to do it, okay? Connie, it's always nice talking with you, okay?
Thanks, Sam. Pleasure to be here, as usual.
We will see you next time. Thank you.